Okay, I'm going to go live and then I'll let you know when we're being recorded. The case is now being recorded.
Functionally, we'll say good afternoon. Welcome to the appeals court. I am Justice Meade. With me today are Justices Blake and Desmond. As sometimes there's issues with Zoom arguments, if we have a technical problem, we will reestablish contact as soon as we can. No one will lose any time on their argument. Hopefully nothing like that will happen. We all have notes either on our lap or for me, I have it on a different screen. So if I'm not looking directly at you, I'm not watching ESPN. I'm looking at my notes. So with that, I'll call the next case. It's 23P 364 CORTON LLC versus Lexington Insurance Company. Mr. Balco.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court, Douglas Balco on behalf of the plaintiff appellant. This is an insurance coverage dispute in which the appellant, which operated a French restaurant in New York City, seeks to recover benefits under an all-risk policy that it purchased from the defendant, Lexington. At the outset, Your Honors are aware from the briefs in the record that it's our position that New York law controls, and the trial court in this matter decided this case principally as a matter of New York law. I think you're also probably aware that this very issue is before the New York High Court, the Court of Appeals, in the matter of Consolidated Restaurants versus Westport Insurance. I'll just update the court.
Counsel, why wouldn't we stay this case until the New York court rules?
Well, I filed a motion to stay the case early on. Lexington objected, given the briefing schedule, and there was no action on that motion to preserve my client's rights. I went ahead and briefed the case.
No, I understand. Timeline-wise, in terms of New York, any sense of how long ago it was argued, realistic time that we might see a decision?
And that was going to be my update for the court, Your Honor. The Consolidated Restaurants case was argued just last week, whatever day the 10th was. I guess that's Wednesday or Thursday. So as of this morning, there is no decision from the Court of Appeals. And so the state of New York law hasn't changed since the parties completed briefing back in the summer. As far as how quickly they move through cases there, I don't practice in New York state courts. I couldn't give you any kind of realistic estimate. A few months, I guess.
Would you agree that Massachusetts law squares with New York law on this issue?
I would agree that Massachusetts is largely consistent with New York law on this issue. I think still we have to honor the choice of law principles. The location of the insured risk is the principal factor to consider in conflicts of law analyses. CORTON operated a business in New York City. Lexington issued a policy covering property in New York City.
So is that to say that you want us to wait to hear from New York? Is that what I hear you say?
I think that the state of the law as it stands from the appellate department's decision is consistent with the Verveen or Vervine case from the SJC. That doesn't mean that that will necessarily be the same in a matter of months. And under no circumstances would I think Massachusetts would have a greater interest or greater relation to this case than New York, given the—
Is that a yes? Do I hear you say you want us to wait for New York?
Yeah, yes, Your Honor.
Go ahead.
So with that sort of preliminary note and turning to the case, the essential issue is whether the appellant has adequately alleged that it sustained direct loss or damage to its property. It is our position that the complaint describes in detail that the virus was present within and frequently reintroduced into the premises, that the virus's presence materially and physically altered the air, the fixtures, other items within the premises, which resulted in the need for remediation, changes to operation, danger that had to be addressed and resulted in costs.
You agree that that argument is an argument that has not carried the day in many, many courts across the country?
I agree. I do agree, but
including the SJC here in Massachusetts.
Correct, Your Honor. I don't dispute that we're not in the majority position throughout the United States. With that said, the coverage trigger is direct physical loss or damage to the property. That phrase is not defined in the policy. And so under established principles of New York law, we must apply the plain and ordinary meaning of those words with reference to dictionary definitions. And then we construe those words in a manner consistent with the expectations of the insured and in a manner that maximizes coverage. And again, because the coverage triggers are presented in the disjunctive, there's coverage if there is a physical loss or a physical damage, or if the claim can fairly be characterized as both. And physical commonly is understood to mean simply material. Damage is loss or harm, and is generally understood to entail some sort of physical alteration, demonstrable change to the property. But loss is defined more expansively. It can mean destruction or ruin, which is sort of coterminous with damage, but it can also mean the partial absence of a capability to function, which they're not one and the same. And in our view, that the trial court should have engaged in this interpretive exercise when the motion was before the court last year. The memorandum of decision does not assess the plain meaning of these coverage triggers. In fact, the court didn't seem to acknowledge that there are two separate coverage triggers at all, and appears to have merged the two into one. And in doing so, essentially equated physical loss with physical damage. We think that this sort of narrow approach to interpretation narrowed the court's view of the allegations of the complaint and ultimately led to the wrong outcome. I appreciated that the consolidated restaurant case is an elephant in the room, and I obviously can't ask this court to reverse the decision of another state's appellate court. But I do want to emphasize a few things. First, the appellate division in consolidated restaurant did not hold that COVID cannot cause physical loss or damage as a matter of law. So any argument that losses caused by the virus are automatically disqualified, I think, overstates the state of New York law. But we also think our complaint is more detailed than what was before the appellate division in consolidated restaurant. The appellate division noted that it was evaluating essentially whether the actual or possible presence of COVID causes loss or damage. In other words, the court felt that the plaintiff had only alleged viral presence and sort of vague allegations that the virus was contagious and hard to glean were sprinkled in. We've alleged actual presence definitively, which we identify COVID as a physical, tangible substance. We've explained a lot about the virus, how it alters property, how it impacts functional capability and causes loss. Paragraphs 38 and 48 specifically, it's a highly resistant substance that can survive for significant periods of time, is resilient to cleaning efforts, ordinary cleaning efforts.
So are you aware of any other cases at the trial court or appellate court levels that have construed the Lexington Insurance Company policy in the way that you're construing it?
Under New York law?
Actually, under any law, but we can start with New York.
Well, under New York law and with respect to COVID, I mean, the cases are largely against us. I think that the Schlam decision, which is a pre-COVID case, but also is a case interpreting loss or damage under a similar business interruption policy. This is the 9/11 case, which is cited in our briefs. You have dust and smoke from the World Trade Center destruction. The court found coverage and specifically held the presence of these noxious particles and substances clearly caused loss because they impaired the insured's ability to use its property. It's obviously a different pathogen from COVID-19, but the case is, I think, highly analogous because you have a dangerous, even lethal substance persistently present within insured property, altering the air, altering the fixtures, and disrupting operations to the insured's loss. So I think if we're analyzing loss separately from damage, which we must, and construe that term in the light most favorable to coverage, the complaint states a claim. The Irvine decision, I mean, it's not a high point of our brief because we think New York law is more appropriate than Massachusetts, but it's noteworthy because the court specifically held, and just find the quote, persistent pollution of a premises requiring active remediation efforts is sufficient to constitute direct physical loss or damage to property. And the pin site for that is 544. And Provide then cited to a number of cases where there was no physical alteration of a building or structure, but instead an invisible substance infiltrated the property and caused a loss. In those cases, we also rely on the Gregory packaging case, which involved ammonia, which is a gas, Farmers Oregon decision, which involves odors from a former meth lab. And this authority is kind of in line with the treatises, specifically the CORTON insurance, which we reference in one of the footnotes in our reply brief, footnote 2 of our reply brief. Contamination by persistent chemical or biological agent not otherwise excluded from coverage may cause physical loss if it renders insured property unusable, even though contamination may be gaseous, microscopic, or invisible. Covered losses are not confined to obvious physical changes. At the appellate level, and to address your Honor's question and circling back, I mean, we rely on the Huntington case from Vermont pretty significantly. Not that it's binding, but its approach to interpreting undefined policy terms, these very policy terms.
Doesn't Vermont have a different pleading standard?
Say again?
Doesn't Vermont have a different pleading standard?
It was a motion for judgment on the pleadings. So yeah, it was a different pleading standard. But I think the interpretive exercise is really what's critical from our perspective in terms of how do we look at these terms in isolation, apply them to the allegations set forth in a pleading. And it's at that point that you look at, you have a difference in pleading standard. But before that, how do we view the language of the policy in a way that's plain and ordinary meaning and consistent with the expectations of the insured? I guess, and I don't see a clock, so I guess with the remaining time I have,
in the upper left, you're at
3:14.
3:14 left.
Yes.
Yes.
Okay, so just a couple of appellees' positions with my remaining time. I think Lexington's interpretation of direct physical loss presents the court with a false dichotomy. It argues that you can either have essentially wholesale destruction of property, in which there is coverage, or you have pure loss of use, in which there is no coverage. I think the Newman-Myers decision, that's 17 F sub 3rd, 323, illustrates why that dichotomy is incorrect. That was the Superstorm Sandy case where the Con Edison cut power in certain areas before the storm hit. This is obviously a pure loss of use, and the court correctly decided that there was no coverage. But the court also cited favorably to pre-COVID cases holding that the presence of noxious gases, toxic gases, and invisible fumes can result in loss even where there is no corresponding structural or visible damage. In other words, the court recognized that under New York law, there is space for claims that constitute loss or damage when there is something less than wholesale destruction, but more than loss of use. So I think loss of use is a natural consequence in any business interruption case, but it's not the sum of our allegations.
So what more than loss of use do we have here? Which may seem the obvious question, but just tell me, have you had to throw away any of the restaurant's materials? I mean, what you tell me.
The main thing is and again, we didn't plead the full evidence that we would have established had we gone forward with the case to quantify the damages, but we certainly allege that based on the persistent viral presence in the property, we had to remediate. We had to replace air systems, the HVAC system, and reconfigure and remodel the interior of the premises, including paying vendors and so on and so forth. And I think that cases that talk about the need to remediate when there is the presence of some sort of perhaps microscopic or invisible but dangerous substance like asbestos or one of the other pathogens that we cite in our brief, that counts.
Right. So once you did all those things, and so you had loss of use for that period while those remediation efforts were ongoing. But once you did them all, the restaurant opened back up?
Eventually, yes, Your Honor.
Okay, so what more than loss of use?
Well, again, there was, there's costs that went into reconfiguring the spaces so that it could be done, and alteration to the systems such as the HVAC system had to be repaired and upgraded.
I see.
7 seconds.
7 seconds. Well, with that, I'll just rest on my brief and thank Your Honors for your time.
Thank you. Mr. Moskowitz.
Thank you, Your Honor, and may it please the court, Keith Moskowitz on behalf of the appellee Lexington. Let me begin by first just expressing my thanks to the panel, also for the professional courtesy of Attorney Balco, who had a few phone calls with me from the airport yesterday. I apologize. Obviously, I can't cure the weather, but I'm sorry I couldn't be there in person. I appreciate the court allowing the proceeding to go forward by Zoom, so thank you. Your Honors, let me first take up the question you asked Attorney Balco at the top of his comments regarding a stay. Let me just deal with that first. Of course, I appreciate that a stay is discretionary with the court, and therefore, if the court wants to wait for the CRO decision to be handed down by the New York High Court, it has the discretion to do so. I would argue here, respectfully, that the court should proceed and issue an opinion for 2 reasons. First, the appellant made the decision to file this case in Massachusetts. This is a policy issued to a policyholder in New York, covers a restaurant in New York. My client, Lexington's Massachusetts Corporation, so there was no issue with venuing the case here in Massachusetts. However, having made that selection and looking at choice of law principles, the first question is there a conflict between Massachusetts and New York law? And the answer is no. As I think counsel fairly acknowledges for the appellant, the Verveen decision of the SJC is on all fours with the consolidated restaurant decision in New York. In the absence of a conflict with the case formed, venued here in Massachusetts, Massachusetts law should govern. Now, again, I appreciate the New York court could rule that theoretically in the future there could be a conflict, but it is notable that having made the decision to bring the lawsuit in Massachusetts, not New York, and there was no impediment to bringing this case in New York, where we find ourselves procedurally, both at the trial court level and even here today, is with no conflict in the law and a controlling SJC decision that is directly on point. The second reason not to stay the case is that we have a long track record in New York with respect post decision in the consolidated restaurant case of courts entertaining and disposing of similar complaints, both at the trial court level as well as even in the Court of Appeals. And so in our briefing, we set forth all of the cases that have been disposed of in the New York trial courts, a decision by the New York Appellate Court itself post-CRO, as well as a Second Circuit decision refusing to certify to the New York High Court the legal questions that are at issue in CRO. So the bottom line is that in New York, the actual experience of the New York courts is that the insurance companies and the policyholders are having their cases fully adjudicated with the recognition that CRO has been on appeal and, as Counsel Balco points out, is sub judice and fully argued. Indeed, outside New York, the Connecticut...
I take it they're being adjudicated in your favor.
They are, Your Honor. So there's an unbroken line of decisions, and that's fair. They all are coming down and following it, but I would respectfully submit that is because the legal reasoning in CRO a consolidated restaurant, the legal reasoning of the SJC and Vervine, and the overwhelming majority of case law across the country is the correctly reasoned jurisprudence. And as a consequence of that, I think the reason why, respectfully, in the New York, the Second Circuit Court of Appeals makes a point of this in denying the certified question. They point out that this is not a situation in which we've got a single decision in New York, we got a high court case. The Second Circuit points out we've got legions, an unbroken line of decisions. So we have this jurisprudence, which has now been ventilated all throughout New York, in the federal courts, in the state courts, at the trial court level, at the appellate court level. The decisions are all extensive and soundly reasoned. We have decisions in the overwhelming majority of other jurisdictions, including state Supreme Courts, federal circuit courts of appeal across the country. And so when you look at that full legal landscape, I would respectfully submit we're dealing with a different scenario when the court should evaluate the state considerations, because we're not looking at this on a fairly blank canvas. We have a very rich, fully informed canvas of well-reasoned decisions, including this unbroken line of decisions in New York. And that's why, respectfully, we opposed a stay, and we would continue to oppose a stay for that reason, and ask this court to dispose of this appeal. And of course, we ask the court to affirm the trial court's decision, dispose of the appeal in our favor.
Mr. Moskowitz, not to put too fine a point on it, but I would just want to be clear. You're not aware of any case across the country where the Lexington Insurance Company policy at issue here and the language at issue here, that a court has ruled the way that Attorney Balco is asking us to rule?
Yes, Your Honor, and I will represent to the court. I am the national counsel for Lexington's part of the AIG group of companies, so I'm familiar with all the cases that the company has. The cases have all gone in our favor on the policy language at issue, both as to the question of is there direct physical loss or damage, but also separate and independently on the exact same contamination exclusion, which bars coverage for virus, that exists in this policy.
That's your alternative argument here.
That is, Your Honor. And again, in taking into account the factors in weighing whether to stay or not, it's not simply, there isn't simply a basis to dispose of this on the threshold insuring agreement question. Separate and independent from that, there's an exclusion, the virus exclusion. And as we lay out in our brief, and to answer Justice Blake's question with a finer point on the exclusion, we've cited the cases, including the Northwell case from the Southern District of New York, interpreting that exclusion under New York law, rejecting the exact arguments that the appellant makes here as to why the exclusion should not apply. So we've got that case law set forth in the brief, this exact exclusion, finding it clear, unambiguous, and applying it to bar coverage, notwithstanding any of the threshold arguments that this panel just engaged with the appellate about, right? So even if this court were to go in a different direction from the SJC, from Consolidated Restaurant in New York, and from the legions of cases, would still have to confront the virus exclusion, where every application of this exclusion in other cases has been enforced by the courts. With respect to the threshold questions, I'd like to use my time just to respond to some of the points that appellant counsel made. First, it's important to go back to the complaint itself, as opposed to the characterization of the complaint in the pleading. And I would respectfully direct the court to paragraphs 76, which is at record site AI 25, and 77, paragraph 77, also at record site AI 25. And there is the crux of the appellant's argument that either COVID-19 is a covered cause of loss because it's a risk of physical loss or damage, or government closures is a covered cause of loss because there's a risk of physical loss or damage. Both of those main points, and obviously I see that in other paragraphs in the complaint, there's an effort to flesh this out, but those are the 2 points. And I would start with the issue of government orders, which wasn't mentioned at all. But government orders is pled as a covered cause of loss. And both the SJC the New York Appellate Court, and every other court I'm aware of the country has rejected the argument that a government closure order constitutes direct physical loss or damage to property. But it's important to raise that because it wasn't raised by the appellant, because we know why restaurants curtailed their business activities, and we know why they resumed full business activities. As pled in this complaint, the restaurant curtailed its business activities where various government closure orders in New York were put into effect, just like in the Consolidated Restaurants case, involves other restaurants in New York, just like in the Verveen case in front of the SJC, which is another restaurants case. So we know these restaurants curtailed their business operations right when the government orders were put into effect, and there's no pleading to the contrary here. And we know they reopened back up for business in full once the government orders were lifted. And so regardless of the presence of COVID on the property, the insurance policy has a critical causation element that's not spoken to by the appellant. The covered cause of loss has to cause the loss. So even assuming arguendo that COVID on property could cause physical loss or damage, which again, that's rejected by the SJC, rejected by Consolidated Restaurant, we have to look at the actual cause of the curtailing of business operation at the restaurant. And it curtailed because the government said you had to change your business operation, and then it resumed full operations when the government said you could. That was the experience with every restaurant in the United States of America, including in New York, including in Massachusetts, and so on and so forth. And that's what decisions reflect. So that is an independent basis to find the non-existence of coverage. And here, I wanted to start with the pleading and paragraph 76 because it's expressed in 77 because the government orders in 77 is expressly alleged. This is not a case where the plaintiff's saying the government shutdown orders didn't have anything to do with causing my loss. It was physical loss or damage from COVID. They've actually expressly pled the government orders. With respect to the presence of the virus on the property and this argument that somehow the pleading in the CORTON case, the complaint is different than in Consolidated Restaurants, I'd make 2 points. The first thing I would start in Consolidated Restaurant, and I could do the same exercise in Vervine, is this quote, which appears at 205 Atlantic 3rd at page site 84. Plaintiff argues that those decisions, they're talking about the New York trial court COVID decisions, are distinguishable because the policyholders in those cases claim financial loss attributable to the executive orders shutting down their business. But its claim is that COVID-19 actually damaged its property by altering surfaces of its restaurants and the air within them, resulting in physical loss. This is a distinction without a difference. Neither the government orders nor the presence of the coronavirus inflicted direct physical loss or damage to any of these properties for purposes of property insurance. And that is the fundamental point of Consolidated Restaurants. And importantly, in the absence here of direct physical loss or damage, what Consolidated Restaurants is talking about, what Vervine is talking about, is COVID-19 in the property, whether it's settled on property, whether it's in the air. The fundamental point of Consolidated Restaurants, and it's the same thing in Vervine and the legions of cases across the country, is that that doesn't cause direct physical loss or damage. And that's precisely why, if one looks at the Consolidated Restaurant decision, the court in Consolidated Restaurant not only found the way it did no coverage, it also rejected a motion from Consolidated Restaurants to amend its complaint to expand upon its allegations, to add the types of additional allegations perhaps the court and plaintiffs contend they have here. And the New York Appellate Court said no, they rejected that. They said none of your amendments are going to change the fundamental fact, which is exactly what the SJC recognized in Vervine, and that there's no physical loss or damage when COVID is on property, right? All it's causing is a temporary loss of use. And then again, I go back to the causation point. It's causing a temporary loss of use in actuality, or it did, because of the government orders. That's why the business operations changed. But it was very much temporary in nature. And there I would direct the court to, again, the CORTON decision itself. the words direct and physical modify or qualify the phrase loss or damage to require a showing of actual demonstrable physical harm of some form to the insured premises. That's not a temporary loss of use of the property because the government said you had to change the way you use the property as a consequence of the coronavirus. Finally, to get to Justice Desmond's question regarding what actually happened to the property, as Consolidated Restaurants pointed out in that case, there was no pleading that any part of the property was damaged in a way that didn't allow it to be used. And that's the exact same thing that's pled here. So when you look, for example, at the HVAC system, which CORTON focuses on in particular, there's no allegation it was damaged, right? Consolidated Restaurants in Vervine have already said that the presence of COVID virus, for example, in an HVAC system is not physical loss or damage because it's settled on the property, and that's the fundamental ruling of the case. But there's no allegation that HVAC system was replaced because it was damaged. That allegation about the HVAC system is built into other modifications, like putting a plexiglass shield on this podium I'm in front of, what courts used to do, so that when I expelled coronavirus, it got blocked. That's not physical loss or damage to property, and that's what Consolidated Restaurants and Vervine both point out. Finally, on sham and the other cases, Consolidated Restaurants and Vervine take on all of those cases. They say they're all distinguishable, and they're not, and they're different from the facts here. And so none of those cases, for the reasons set forth in Consolidated Restaurants and Vervine, including sham, Gregory Packaging, apply.
Okay. Thank you. Thank you both. We'll take this under advisement.
Your honors. Have a good day.
Thank you.